Hi, everybody. My name is Dan Timins, and it has been a long time since we have gotten together to do one of these webinars together. So it's exciting to get back together with everybody here. So today I figured we would talk about transferring your co-op to a trust. And when I say your co-op, I really wanted to make this program not just for clients and people who own co-op shares and are considering placing their co-ops into trust, but also attorneys. I do want to tell attorneys who are involved in this presentation, I did this exact type of presentation, but in a continuing legal education format with law lines. So if you ever want to see the unadulterated continuing legal education program, that's fine. But I wanted to also make this a program where people who own co-ops can understand exactly the reasons why we place co-op shares in proprietary lease and trust, how we do it, and things that may stop you from doing that. Again, as always, I am welcome to take questions along the way. Just depends on how much time we have. Sometimes it just gets really busy. So as we are going through, if you do have questions, feel free to ask them. But if I don't respond to them, please understand I'm trying to get through a decent sized program. But ask questions as we go through, and I hope to answer them. Anyway, so that is what we are going to be discussing today. But first, here's the disclaimer. Once you see it, you can't unsee it. This is attorney advertising. Look at me a few years ago. That looked pretty good. I was a little pale, but I had a lot more hair. But I'll tell you what, I still have that tie, and I love that tie. I almost wore it this morning. Anyway, keep this in mind. This is attorney advertising. If you want something to happen with your own specific situation, this program may help with initial guidelines, but you're probably going to want to retain another attorney. And there's no guarantees that anything I tell you today is going to be the law in the future, or that you'll necessarily get the same results that I am currently providing to clients and state that I am doing here in this program today. Today's topics, let's go over really quickly what the topics are. First of all, basic concepts. What is a trust? What is a co-op? And then why are we going to attempt to try to transfer co-op shares into a trust? What is the actual transfer process that's involved? And this is good for both clients and attorneys. So far, all this is looking good. What problems may arise? This you should pay attention to if you're planning on doing a transfer to a co-op. Just know what are some of the roadblocks that will lead to problems that are going to come up along the way. What documents are required to actually get to the point of being able to get to a closing and change your co-op stock and lease into a trust. And last but not least, Article 6 is really primarily for attorneys. It's what you need to do as an attorney to prepare for a closing. You know what? I'd say if you're a shareholder, you may want to stick around for that. That's a little bit more dense, but just so you know what to expect in the future, feel free to stay there in the program at that point. Here are the key takeaways before we really start rolling. First of all, if you own a co-op, find that original stock and lease. We refer to it as the stock and lease. The technical term is stock certificate and proprietary lease, and I'll explain what that is soon. But basically, find your originals. If you have a mortgage, you probably have the original proprietary lease, but not the stock yet. Look, get that stock back when that mortgage gets paid off. Just remember, second key takeaway, the co-op has the ability typically to reject your trust. They do not have to accept your trust. Depends on co-op to co-op, but the general approach is that they may reject your trust. Trusts are also not an automatic backdoor to allow your child to live in a co-op when you die. I have a kid who's a good for nothing kid, but I love them. But you know what? They never make any money, and they have a lot of, liens and other issues associated. And by the way, they have a big dog, and they have, a boyfriend or a girlfriend who's a real mess that they bring into the apartment. The co-op doesn't have to allow them to live in the lease. The trust is not a backdoor into allowing your child to be named on the proprietary lease. I suggest that you work with an experienced attorney if you plan on transferring your co-op into a trust, and you will see why very quickly in this presentation. And I ask all clients to be patient. If you are a shareholder and you have co-op stock and lease that you wish to place in a trust, there are many parties involved. There are many processes that are involved that differ place to place and different co-op to co-op. There are different fees. There are different things that can just hamstring your transaction that you're not familiar with. So always the rule of the day is to be patient. We already have a question. Will you talk about, will your talk be applicable to condos? Sorry, Patricia, not condos. Today is all about co-ops. And the reason why is specifically because condos are easy. If I want to change my stock and lease, I need to have it done through a board. But if I have a condo, I have a deed, I just need to do a deed change. There's no one I need to get permission from to change my ownership of my deed to my condo. So if you're here for condos today, not a great day for you. Well, I think it would be great. You have a lot of educational information ahead of you. Thank you, Patricia. So that being said, let's move on. Today, we're going to be talking first about what is a co-op, what are their operative documents, and the parties involved with co-ops. We'll again do a brief review of what a revocable and an irrevocable trust is. And just remind people, we're not talking about trusts created by wills, which are called testamentary trust after your last will and testament. That's not what we're talking about today, and I'll explain why. First of all, what is a co-op? A co-op is a corporation. Remember when your grandpa bought IBM stock and he actually had a certificate that said he partially owned the corporation? Well, a co-op is a corporation. And the corporation owns real estate. You do not own the real estate that you live in when you own a co-op. If you don't know that already, surprise, surprise, guess what? You don't actually own the apartment you live in. It's a corporation that owns the real estate, and the corporation is run by its shareholders, just like IBM was run by its shareholders. They elect a board of directors. Same thing as with IBM. You know, this is a corporation. You have a board of directors for your co-op as well, who usually tend to be the shareholders. And that board of directors and the co-op and the parties that are involved may or may not issue a proprietary lease to the shareholder. The right for you to live in the apartment is very different than owning the financial interest in the apartment. You will see. And I guess the people that this affects the most, and if you're joining us from Florida, hey, maybe you're doing it because you still have a piece of real estate up here in New York, you know, co-ops, at least in the apartment term, are primarily located in New York State, specifically in the New York City boroughs, Westchester County, some in Nassau, you know, but the further away you get from New York City, the less and less you're going to be finding co-ops throughout the state of New York. Okay. What are the operative documents regarding a co-op? Well, the first thing is the stock certificate. That shows that you actually have a financial interest in the co-op. I refer to that as your stock. Like that IBM stock certificate, that is the financial right to own a part of this corporation. The proprietary lease, it is a lease. You get a lease to live in the real estate that the co-op owns. We call it proprietary because you have the best right to live there. You can't just have your lease reassigned by the co-op. It's proprietary. You are the person who has the right to live in that part of the co-op. So it's proprietary. But I refer to it as the lease. So there we got our stock and our lease. There's an operating plan that was, offering plan that was originally created by the co-op when it went co-op. There are bylaws. Bylaws are written rules as to the co-op. A lot of things you can and can't do in the co-op, like can you lease your co-op? Or are you able to give it directly to your spouse? A lot of these things will be in the bylaws, and bylaws occasionally change in the form of amendments lower down. We have house rules, and there are minutes regarding board meetings. Typically, what board meetings hopefully lead to are, you know, basically the position the board takes on ambiguous answers or issues that are in the bylaws that don't have specific answers. So who is this board of directors? Well, they are typically shareholders of the co-op. Some co-ops allow for spouses to be members of the board of the, board of directors. And that board of directors typically gets to run many affairs concerning the apartment, or at least the co-op, at least speaking to the management company. Their big point here in our discussion is that they can approve or disapprove of the tenancy, meaning they can decide whether or not a proprietary lease is appropriately being given to the right person. So they can deny tenancy for many, many reasons. This is the problem. I'm a rock star. I'm Howard Stern, and I want to live in your building. I love Howard Stern. Clearly has plenty of money, but, especially several years ago, who knows what he's doing in that apartment? And there are going to be all these crazy fans outside. We don't want Howard Stern. So they have reasons to say, you know what, we don't approve of your tenancy. We don't want you to live here. We're not going to allow you to, become a tenant here. That's the standard co-op answer. In the old days, there was probably some discrimination going on there. In the new days, it's still there, but I don't see it nearly as much as maybe 20 years ago. People are basically trying to worry about, the board is worrying about, are you going to be a good fit here? Or are you going to have a dog that you always let off the leash that's going to bite kids? Sometimes the board is limited to only having a right of first refusal. So if you decide to give your apartment to your child, they can or cannot say, all right, well, we're not going to let them live there, depending on the bylaws. They may have the right to say, instead, we have the right to buy the apartment from you. Again, it depends on the co-op. And if you're fully out of compliance, the board has the ability to evict you. Again, if you're letting your dog bite kids, if you aren't paying your maintenance, if you continually bring in bed bugs and they're affecting the other apartments in the buildings, you say, I don't care, I like these little bed bugs. Board can evict you, okay? Then there's the management company. The management company is the one that actually does a lot of the heavy lifting regarding, the day-to-day maintenance of the building. So they're collecting maintenance, the actual charges. They, arrange for repairs and construction. When you tell your super, hey, there's a big leak right here, they're going to call up, the management company who's going to get in touch with the service provider, the plumber to fix the building, et cetera, et cetera. They also field shareholder complaints and they manage the co-op's finances. So there's actually someone at the management company who's balancing the checkbook, who's writing out the checks, who's making sure that the accounts aren't getting close to zero, et cetera, et cetera. They report back to the board of directors. But the management company is what you would expect. They are managing the co-op's affairs. The interesting thing to note for management companies, they are habitually understaffed. It's not their fault. It seems to just be a nature of the industry. Every co-op wants more service. Every management company wants to try to charge more money, and they kind of get stuck with people who are continually overworked. It's not one management company's fault. Yes, there are differences between one management company and another, but just keep in mind they are often overworked. So, the problem is that everyone has to make money, and there are only so many people we can employ. There's the co-op's attorney. The co-op's attorney is the one that sends things like eviction notices to people in the co-op who are not paying their rent, or that, again, are causing major problems. They represent the co-op in any legal disputes, such as, hey, the city is saying you guys didn't replace the sidewalks early enough, so now we're going to fine you. The co-op's attorney is supposed to kind of like say to the city, hey, you didn't give us adequate warning, et cetera, et cetera. And they are a major party involved in the transfers that we are going to be talking about today. So we are going to be talking about the co-op's attorney. And then the question is, okay, well, now we know what a co-op is and who's involved. What is a revocable trust? A trust is a legal document that an attorney writes up with you, or hopefully an attorney is, and you're not just getting off of some website. It's created during your life. It's not a part of your will. It's a separate legal document, which tends to have your full control. If you create the trust, you administer to the trust, and you can use the money for your benefit, provided you fund that trust. My bank account is no longer owned by Dan Timins. It's owned by the Daniel Timins Revocable Trust. In this case, my co-op shares and the proprietary lease, they're not in Dan Timins' name. They are owned by the Daniel Timins Revocable Trust. Daniel Timins as trustee. That's what we call funding the trust. You actually have to have the trust be the owner on named types of property, like your brokerage account or your co-op shares, or in Patricia's question, your condo. Your deed should be named after your trust. You can modify a revocable trust. The whole idea of being able to revoke a trust means you can also be able to modify it, change it, etc., as long as you are alive and compos mentis. And it transfers property when you die without having to go through the probate process. That's one of the big reasons people like trusts. You don't have to go through this cumbersome public process called probate, which we'll review. And I want you to remember, just always, I already brought it up in key points, but I want you to dig this right in your head. The co-op has the right to disallow trust ownership if they don't like your trust. Remember, the co-op decides who gets to live in the apartment, and they can also say, hey, this ownership is not permitted on our stock certificates. So just creating a trust, you still have to fund the trust, and the problem is you need the co-op to help you fund your trust with the stock certificate, because it's the co-op that changes the stock certificate. I mean, technically they're attorney, but you get what I'm saying. Okay. So these are parties to the revocable trust. You create a trust. You are the responsible individual. You are the trustee, and you are the beneficiary during your lifetime. This is kind of like my alter ego, right? I work hard and I create money and I administer to it. I pay my taxes. I make sure I try to invest a little bit of it. and I put the rest of it in the bank account so that I'm the beneficiary. I can enjoy my frosty drink at a poolside with an umbrella at the top of the drink, and maybe an umbrella over me if I got to the pool early enough. That is the idea of being a revocable trust. It is your alter ego. In this case, the trust, you create it and you fund it. You are the one who changes the owner on your stock certificate for the co-op with the help of the co-op, or your brokerage account or your bank account. You administer and pay for the bills. Since the trust now owns the co-op shares, guess what? You are the trustee, you pay for the maintenance, and you get to live in the apartment during your lifetime. And when you pass away, someone else is able to own the trust property without having to go through probate. So the name on your stock certificate is going to go from Dan Timins, whoops, that went a little faster than I wanted, Dan Timins as shareholder, to the Daniel Timins Revocable Trust, Dan Timins as trustee becomes the shareholder. So that's the language you're going to see on your stock certificate once this process is done. The name of your trust with you as trustee as shareholder. That is for a revocable trust. Well, what is an irrevocable trust? This might be what brings a lot of you here today. We only have 3 reasons that we create revocable trusts. You know, revocable trusts avoid probate too. Not a big deal. I mean, it's a big deal to avoid probate, but basically speaking, you know, that's standard. Why do we need an irrevocable trust? Well, because either we get extra estate tax savings, we may qualify for government benefits like a Medicaid trust. That's what brings a lot of people to this program today, a Medicaid trust. And you may have an irrevocable trust that gives you creditor protection. Now, just because you have one irrevocable trust, it tends not to be all 3 of these, right? Each trust tends to be different. You're either getting estate tax savings, Medicaid benefits, or you're getting creditor protection. I submit to you, these are the only 3 reasons, at least 3 good reasons, to create an irrevocable trust. Yeah, if you want to trick your mom, leave all this money to you instead of your sibling, you could say, here's an irrevocable trust, mom, you can't change it, and I'm the sole beneficiary and I'm the trustee, and mom signs it. I don't think that's what most people want to do. So I think these are the 3 only good reasons to create an irrevocable trust. I know Medicaid is one reason. So you tend to create a trust to begin with to avoid probate. And if it's an irrevocable trust, you create it for Medicaid purposes, or you use it for estate tax savings. Now, remember, for an irrevocable trust, if you create it, you can't be both the trustee and the beneficiary. And for some trusts, you can't really be either fully. So for an irrevocable trust, you tend to create the trust and you fund it with the co-op shares or with your brokerage account. You are typically the trustee, but if you are, you're not the beneficiary. If you are the beneficiary, you're typically not the trustee. There's like a big line over here. And with Medicaid trusts, it's even a little bit more complex than that. So anyway, the idea here is the owner on your stock certificate will go from, whoops, I'm sorry, I did it again, from Dan as shareholder to, you know, let's say Julie, my mom, as trustee of the Daniel Timins Irrevocable Trust as shareholder. So you, the creator of the trust, are most likely taking your name off the stock certificate and you're creating the Medicaid trust, which will now be the owner with maybe your child named as the trustee. Now, we're not talking about trusts that you create in your wills. And again, I see some questions coming up. I'll answer some of them in just a moment. You know, you can create a trust in your will. The problem is it's not created until after you die. So your will can create, your last will and testament can create testamentary trusts, but these tend not to be what we talk about because you are not getting Medicaid or extra estate tax savings from that testamentary trust, and you never got the co-op's approval. So the co-op doesn't even have to pay attention to testamentary trusts. They can say, you can leave the stock to whoever you want, but we're clearly not going to let the testamentary trust be the tenant here because you could be naming anyone you want. You could be naming multiple generations of future stockholders here. We never got a chance to review your trust, so no. So we're not talking about trusts in your wills. Big note for attorney, if you're trying to leave a co-op to someone's children or grandchildren or ne'er-do-well boyfriend, guess what? Testamentary trust is not the way you want to go because the co-op can straight up reject it. I'm going to answer a few questions really quickly. So I already did that. Anonymous, will you cover Medicaid asset protection trusts? I actually will, and I actually just did a bit. So keep that in mind. That's the whole reason we are going to be going through this. How do you get that Medicaid asset protection trust to be the owner of your co-op? And can't the Medicaid asset protection trust be revocable with just community Medicaid, not for nursing home? Incorrect. You cannot create a Medicaid asset protection trust that is revocable, because what you're saying is I have all this money, but I'm going to give it away. But guess what? I'm going to get a government program that's solely created for the benefit of people who are, impoverished. And then guess what? I can take all the money back. So Medicaid trusts, no, no, no. They cannot be revocable. No, 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 no. Okay, good. We answered that, I think, satisfactorily. Why should I transfer my co-op, my stock and lease, to a trust? Number one, like we said, it avoids probate at your death. It may allow you to get government benefits or estate tax savings. And in some cases, it may protect your family rights to tenancy in the unit. I say may with that idea of, here's Dan really covering his butt, because the answer is probably going to be often no. Okay. Probate is a public process. So when we die with an asset that is not owned by our trust, or does not have a joint owner, or there's no beneficiary, who gets the money? We have no idea. We have to look at this document called a will. A will transfers property through the process known as probate, which is public. A will is a contract between you and the state in which your will is administered to. So if you lived and then you died in New York, your probate is most likely going to be in the state of New York. Not a great state to do a probate in. Not the worst. Good to know that. Isn't it nice to know if you live in New York, you're not in the worst state, at least not for probate. Anyway, so court paperwork and oversight is required for probate. Probate tends to be slow. Not all counties are created equally. So, I'll give some counties, like I'll give Dutchess and Orange County thumbs up. Hey, you don't have so many people die there. So probate, at least you tend to be able to start getting to action, a month or two after you've submitted all the paperwork. They tend to be pretty quick. Some other counties closer to New York, they tend to be on the 3-month side. Some counties in New York, to actually be named as executor to the will, to say 12 months at a minimum, it's not incorrect to say that currently. I'm not talking down to the court, because God knows I need them all the time and they're overworked, and God knows plenty of attorneys and plenty of clients make plenty of mistakes with the court as well. But they're just overworked right now. Probate is not a quick process the closer you get to the nucleus of the city. I'm not calling out any counties in particular, but you know who you are. And there are court fees and attorney fees as well for probate. So probate tends to be a long process, tends to cost money. There's attorneys involved, there's the court involved, there's the weight that's involved. The good news, when you sign your will, there's no work you have to do afterwards. So when you finish your will with Dan, I say, see you later. You say, see you later. You go out to your family, your friends, the bar, a jet game. I don't know why you go to a jet game, but maybe you bring yourself a little bit closer to death. But either way, your job is done. When you create a living trust, the good news is this, you get to avoid probate. So unlike this 3 to 12 month wait, if you pass away, your backup trustee is able to take control the moment they have a death certificate. Could be 2 days after you pass away. Guess what? Your property is already listed for sale. Your brokerage account's already controlled by that trustee. The idea is that a living trust is a contract between the person who created the trust and the serving trustee. There's no state involvement, so there's no court paperwork required. Like I said, this tends to be fast. You only need a death certificate when you pass away, or a doctor's note if you're incapacitated, for this backup trustee to start working. And any of the fees that you typically pay for probate, you tend to pay them up front because you have to fund the trust, and you actually have to pay the attorney for another document. But you probably save 5 times the amount of money by dealing with the living trust and dealing with all these matters up front. The downside is, once you're done signing the trust, it's not, okay, I'm off to the bar. Then you have to fund your trust. You have to change the owner on your brokerage account. You have to update the beneficiary on your life insurance to be owned by, or maybe not owned, but the beneficiary will be the living trust. And in the case of co-ops, you have to change the stock and lease to be owned by the trust. This is more of a pain in the neck than changing your brokerage account. And that's why we're here and we're talking about the ups and downs. When you die, if you go through probate, I went through a lot of these problems. The biggest cost is a lost opportunity cost. Why? If you own a co-op, you still have maintenance coming out every month, right? You got to pay the maintenance now, or if you die and you're not paying them when the co-op finally gets sold or before they transfer the shares, someone's got to pay all that past due maintenance and late fees. Oh, and by the way, you're also paying for utilities. Same thing if you own a home. So that extra 3 to 12 months rate, people say, hey, Dan, you're getting paid so much on probate. I don't think so. Who's really getting paid? It's the mortgage, or it's the co-op, or it's the real estate taxes that are continually being paid because you can't list the home for sale, can't even list it for 3 to 12 months after you pass away until the court gives you access. So this is the reason you do revocable trusts. If the only purpose is you want to avoid all those extra expenses, forget just the probate costs you pay me, these lost opportunity costs, you want your co-op owned by a trust, and frankly, all of your property. So that's why probate, not good. Trusts tend to be good. All right. Remember, you have to fund the trust. The mere fact you create a trust with me, I say, well done, see you later. Your job isn't done. You have to change the owner of your brokerage account from Dan Timins to Daniel Timins Revocable Trust. And in the case of a co-op, you have to change the stock and lease, which is why we're here. The good news is that you are able to control how the money that you leave to your beneficiaries is spent with a living trust, whether it's revocable or irrevocable. You contain you're like the puppet master. You still have the strings over that money when you die to some extent. Now, irrevocable trust, the question came up. Aren't we going to talk about Medicaid trust? The answer is yes. If you own a co-op, and your co-op allows Medicaid trusts, and your apartment is worth more than $960 some odd thousand, guess what? It's not excluded from Medicaid for home care purposes. And if you go to a nursing home, their nursing home can go after your co-op unless you place the co-op, the stock and lease, into the name of your Medicaid trust. You need the co-op board to permit this in all these parties. So yes, if you have a co-op, and it's worth more than $966,000, and you have a feeling that something's going to go wrong, and you're going to be on home care Medicaid, you want to create a Medicaid trust. If you have one of these really bad diseases, something like Alzheimer's or dementia, or you're just really disabled and you know you're going to get more disabled and there's no chance of you going to have to go to a nursing home, you got to get your Medicaid trust to own this stock and lease, or else the nursing home is going to go after that. So that's a big reason why we use trusts, irrevocable trusts such as Medicaid trusts. We want the stock and lease to be owned by the Medicaid trust so we are not invalidated, or that Medicaid doesn't place a lien against the home. I have also done estate tax savings trusts such as qualified personal residence trusts known as CUPERs. Yep, some co-ops will also allow CUPERs. Not all co-ops will allow Medicaid trusts, and not all of them will allow CUPERs, but the good news is more and more do. I had a question. Oh no, I didn't have another question come up, so I'm just going to say done, done, done. Still accepting questions as we go through. So I want to bring up the fact that without co-op approval, a trust does not provide you with a back door to adding future tenants. Here's the example. I create a trust, and I say my daughter is going to be the owner of my co-op when I die. But I don't ask the co-op to actually look at my trust. I don't need you to. I'm sure that I'm doing the right thing because some guy told me to do this. And that guy also does, landlord-tenant law, and he happens to also be my accountant. Maybe he's not even really an attorney. But yep, you created your revocable trust online and you got it. And you figure, okay, everything's set and good and done. I don't let the co-op look over my co-op. The stock and lease are never updated to be owned by the Daniel Timins Revocable Trust, leaving the trust, to my daughter, Daniela. And then I die. The co-op does not need to accept my trust. I left everything to my daughter. I never showed the co-op my living trust. Guess what? It's not funded. They don't have to listen to it. At best, they may allow my daughter to resubmit a co-op application, but first of all, this goes through probate. And number two, the fact that I said, well, my daughter gets to live there, that's not good enough either. Remember, the co-op gets to decide who is going to be a tenant on the proprietary lease. The fact that I said, oh, my trust says this goes to my daughter, not good enough. The co-op has to approve who they extend the lease to most of the time. You'll see there are a few back doors, but I'll get there in just a moment. And even if you do create a trust, and let's say, you hire Sneaky Dan, and Sneaky Dan is able to place into your trust, guess what? Ha ha ha, I put it in little, 6-point font, you never caught it. Or you know what? I put in such crazy verbiage into the trust that the co-op never caught that. I said, all right, now I'm letting my daughter live here. Caught you, co-op, you're stuck. They have their own documents that are referred to as, I gotta really stop doing that, letter agreements. Letter agreements are separate documents the co-op's attorney drafts that says, by the way, Sneaky Dan, if you did something sneaky, you put it in like that, that old school, like if you rub lemon on it, this print all of a sudden shows up, hidden print. Guess what? The letter agreements they create actually they override anything that I put in there. So there are going to be additional documents the co-op creates. It says your trust actually looked very nice to us. And by the way, even if you snuck something in there, we don't care. We're not paying attention to it because here are other documents that supersede your document. Those are called letter agreements, and we will refer to them again. Please collaborate on QPERTs. QPERTs are their own discussion. If you have a question, ask me afterward. They're their own estate tax savings trust. They themselves are a half-hour discussion, at least for a continuing education class or class 2 clients. So sorry, we won't go over QPERTs. Just know that they can save estate taxes for you and that they're irrevocable trusts. Feel free to reach out to me anytime. Okay. Now, trust may, on the flip side, may better protect spouses and on rare occasion children. So the bylaws of your co-op may allow your spouse to continue living in the apartment, and you may even be able to state that in your trust. Remember, the letter agreements that the co-op is going to place together will be the overriding fact. Your trust in and of itself is not enough. The co-op's attorney is going to create these other documents that can, supersede your trust. So you really want to ask beforehand, hey, and you may want to look in the bylaws, can I leave this property to my spouse, even though I'm the sole owner during my life? And again, on rare occasion, these co-ops also have the ability for your children to live in co-ops without the board specific permission. But I say may as in very rarely. There are cases out there that allow it, but there typically had to be proof and permission for it in the bylaws. Do not assume, especially for your kids, that you can just add them to the trust. The co-op is going to be cool with it. Just remember, that's very few and far between. So the hint for everyone is that you have to remember that children and spouses may not be allowed to reside in your co-op after you pass away. I had a nasty co-op that would not allow my client's spouse to get named and be permitted to live in that co-op after the shareholder passed away. Shame on them. Bad guys. I won't say who you are, but if you're one of those clients who knows what I'm talking about, I'm talking about your co-op, and they're mean. Okay, the moral of the story is you almost always need a co-op's approval to transfer the stock and lease to your trust. Get permission before you attempt to change ownership, right? There's going to be a long process. You don't want to pay an attorney $4,000, $5,000 only to find out, oh, we should ask the co-op if this is even permissible to put the stock and lease into this trust. And again, there are some exceptions out there, but don't assume they will work. Okay, so then what is the transfer process? Just do, whoops, we're done. So what is the process for transferring property into a co-op? The first thing is the shareholder should do some work first. So if you own the co-op, here's the work we're going to ask you to do. Find your original stock and lease. If you can't find it, do you still have a mortgage? You probably have the lease, but if you can't find the stock, maybe that, the mortgaging company, the bank still has the stock. And if you do have a mortgage, you want to know whether or not the co-op will allow you to do a transfer and whether or not the mortgage will allow you to do a transfer beforehand. Does your mortgage have a payoff letter? Did you pay off the mortgage, but you don't have the stock? You need to show proof that you paid off the mortgage, for all clients. Once you pay off your mortgage, I want you to keep that mortgage payoff letter next to your birth certificate and next to your marriage certificate and next to that, your favorite picture of your kids. That is an important document, all right? It's if you get your mortgage payoff letter, you want to put that in a Mylar sheet and hold on to it. You want to know whether or not there's a flip tax due if you change this co-op to a trust. You may have to pay 1% of the value of your apartment to the co-op. You may have to pay 3%. You want to know if there is a flip tax that's due before you go through this process. You want to know if you want to have a revocable trust or an irrevocable trust, whether it's a Medicaid trust or a Q-PERT. And then you want to figure out who the managing agent and the co-op's attorney is. Why? You want to set up your attorney for their due diligence. And if you're an attorney, go back and watch this slide when you, when it's back on my website, because this is the beginning of the work that you need to do. You have to first ask the co-op's attorney if transfers to trust are permissible. The fact that your client told you, that's great. Thank you for the work, client. Now, attorney, it's your job to do that work again. You especially want to ask if this is permissible if you're creating an irrevocable trust. And, you have to ask the bank too. If there's a mortgage, you want to figure out with the bank, not just with the co-op, but primarily the bank. Hey, are you guys going to allow us to reissue the mortgage to the name of the trust? And don't worry, they're going to make sure they can go after people anyway. So that's why you got to figure this out before whether or not they'll even permit it. And if they do, what are the ramifications there? You want to know the costs in the transfer procedure, which we'll go over. You want to confirm how much the co-op's attorney charges, because who knows, by the end of this, they could have a $5,000, $10,000, $12,000 bill if you don't set that up beforehand. And some of these attorneys are just crazy. They just bill so much. And I'm sorry, I'm on my co-op board as well. I love our co-op's attorney. I'll tell you, I work with a lot of co-op's attorney. Not all of them are created the same equally. I'm not saying I know everything. I'm just saying they don't know everything. And you have to confirm some things. Is your client going to need to reapply? Or do they need to put in that, like 30, 50, 150 page application process from scratch? Yep. I've had some co-ops require, and when I say co-ops, it's usually the management company, Doomkopfs, who are asking you to start that whole application process from scratch, even if you live there for 30 years. That's annoying. And remember, some co-ops may say, hey, we get to hold aside 1 year's worth of maintenance in escrow. Yep. So if you have a client who's doing a revocable trust and the building requires it, they may have to have 1 year's worth of cash that they set aside in escrow for the remainder of the time that that trust is owning the co-op. What a pain in the neck, but you're going to want to know that up front. And again, I state if there's a mortgage here as a hint, you better immediately contact the mortgager to figure out whether the mortgage is going to be able to be transferred to a trust. Now, this is when the client and the attorney work together. They discuss what that trust is going to look like. Revocable, irrevocable, what are we going to do? Who gets what? How are we going to do it? That in and of itself will take several weeks. The attorney should order a lien search on both the shareholder, the client ostensibly, the trustee, if it's someone who's going to be someone other than the shareholder, like if it's a Medicaid trust, it's going to be, son and daughter or best friend or sister, and the building. Yep, you have to look at the co-op and run a lien search on the co-op as well. The attorney's work is going to need to be to clean up those liens. And you'll see liens can happen for any one a number of reasons. Some are legit, some are not legit. Sometimes there are errors, sometimes there are blemishes, but it is the attorney's job to do that. You're going to want to bill that or put that into your billing structure. You have to bill for it because you never know how much work is required. At least if there's an errant bill on there because you have, John Smith as your client, you're going to have to say, hey, these are none of John Smith's bills, and you're going to have to put that in an affidavit format, et cetera, for your client. And then you send the proposed trust to the co-op's attorney, if they even care, because ultimately they're going to be creating letter agreements. So this is the work your attorney does with opposing counsel, not really opposing counsel, but the co-op's attorney. They're going to request the letter agreements from the co-op's attorney, and they are going to modify, hopefully, if your attorney's doing a decent job, certain parts of letter agreements. I'm not saying it's required, especially for a revocable trust, but sometimes in irrevocable trusts, you're going to want your attorney to change the letter agreements and get the co-op's attorney to agree to it. What if I'm having a live-in home health aid? Do I need to include that inside my, the letter agreements? You probably want to have that in there unless the, co-op says, no, that's perfectly fine. We never have a problem with that anyway. So like I said, under line item 2, your attorney may want to try to negotiate with the co-op's attorney. They will then schedule the closing and hold the closing, and that will be with you. And it tends to be either with the attorney or the management company's office. And then it's your attorney's job to send in the New York City or New York State tax transfer paperwork. So for all counties in New York, it's going to be TP 584, whether it's in New York City or outside of New York City, like Westchester or Orange County or in Nassau, et cetera, et cetera. And if it's in New York City, they're going to be sending in the ACRIS paperwork, which, surprise, surprise, New York has 3 times the amount of paperwork that it requires than the state does. ACRIS is a lot of paperwork. Your attorney does that. The co-op's attorney doesn't do that. Yep, if you represent your client attorneys who are on here with me, you have to do the TP 584 and you have to do the ACRIS paperwork. Just keep in mind, you're not going to do the water paperwork, because then you're saying, I'm going to have my client pay for the entire building's water. And you don't do the RP 5217 because this is not real estate. That's only for real estate. So if you're transferring a condo for your client, yep, you do the 5217. If you're doing a co-op, no 5217, because you're not dealing with real estate here, you're dealing with co-op. You say, I thought it was real estate. Well, relax. That's not what this program is to discuss. What problems may arise during this transfer process? I'm not going to go through this list exhaustively, because you can see there's a whole bunch of things. Just keep in mind, if you're an attorney especially, or if you're watching this for the first time on my website or on YouTube, these are all problems that can come up. First of all, there's so many parties involved here. Why is this taking so long? Look who's involved: the client, your attorney, the co-op board, the management company, the co-op's attorney, the title company. Why do we say the title company? Your attorney may or may not create that TP 584, and they may or may not run their own lease search, et cetera, et cetera. I have a title company do some of those things, so they get involved. Bonus, guess what? If there's a mortgage involved, now you have the mortgaging bank who's the necessary party. Bonus, if you're doing something because your spouse died, or if you never administered to their estate under certain circumstances, you may have to wait on the court. So that's another huge wait. Then again, you have a title company. If you lost the stock certificate, and the co-op requires what's called an Eagle 9 policy, which we'll discuss. Look at all those dang parties. And guess what? We haven't even started yet. You just contacted your attorney to say, hey, guess what? I want to start doing this process. Or you just talked to the co-op board and the co-op's attorney and say, hey, is this possible? That's why this takes so much time. I say the transfer process should take, I say 3 months, because I've actually done it within 3 months in the last 2 years. A handful of times. And by a handful, I mean like a small handful with a few severed fingers, or 12 months. And I have had some co-ops take 24 months. This process is not a quick process. The fact that you get it done in 3 months, pat yourself on the back. I am amazed. You had a great team involved, not just your attorney, it's all these other parties. Expect this to take 6 to 12 months, frankly. And in certain circumstances with all these parties, expect it to take over a year. Got the court involved, maybe expect it to take 2 years. All right, I told you enough there. Number 2, there's no standard transfer process. This will drive your attorney, if you're a co-op attorney, by the way. I just want you to know your processes are all different. So are management companies. And each attorney has different transfers as well that they involve. So, if you are an attorney representing your client, or if you're the client listening to this, there's no standard transfer process that any co-op seems to deal with. Okay, I know the difference between a transfer that's done with ORCID and a transfer that's done by ACAM, because they tend to have similarities, but the attorney may be different, or this building may do things differently because their bylaws are different. So this can drive people crazy, because you can never quite figure out beforehand how much time this is going to take. Just remember, sometimes the attorney is going to do the entire process, the co-op's attorney. Sometimes the attorney does very little part of the process. They do the legal part, and then they say, all right, the management company closes. But sometimes, okay, the co-op attorney is involved and the management company is involved, and the management company has additional paperwork as their attorney does, and then they have to go back and forth, and then maybe you sign at the co-op attorney's management company, the co-op attorney or the management company, or they may just say, do it at your attorney's place in Article 4. I had to deal with a co-op transfer where the clients were located in California. It was clearly for a New York co-op. I had to do things remotely. I had to deal with both the co-op attorney and the management company, who had different processes that were involved in through this entire process, and the lost stock, and there was a lost stock and lease. It was terrible. You don't know what the transfer process is going to look like. So I would ask you as an attorney, figure out, first of all, who does what. Where's the closing going to take place? It's going to take place at the co-op's attorney's office. That's great. At least you know where you're going. It's going to be the management company's office. Guess what? You already know you're going to be dealing with an attorney, and then you're going to have to do additional work afterward with the management company. So, and if it's at your office as the client's attorney, you're going to do that, and you're going to have just the best of time there. Okay, it was a little facetious and perhaps even a little sarcastic. I do have a fresh question. Approximately fees total. Oh, I will tell you the fees. Don't worry. We will get there. We're on our way, actually. Okay, so the document requirements differ too. Sometimes it's really easy. Sometimes an attorney just asks for a copy of the trust, a lien search, just update the accuracy, and maybe you just sign 1 or 2 letter agreements and it is done. Or this could be a completely maddening process with all types of paperwork. You may have to negotiate the letter agreements. You may send multiple copies of the trust and letter agreements back and forth. You may have to reapply from scratch. Remember that application you did with the co-op? You may have to do that again from scratch. You may also have to do different types of things regarding the court. So you may have to bring in certain types of, letters testamentary if the co-owner died. Or I had someone who died who bought the co-op before 1996, and then their spouse died. They never did any administration regarding. The attorney asked for a marriage certificate, a death certificate, an estate tax lien. They asked for estate tax lien. They asked for a copy of my client's will, to which I said, no way. But, these co-op attorneys could ask you for everything. And guess who's getting paid during this whole time? The co-op's attorney. And so am I, the client's attorney. So, you just kind of stuck with some of this stuff. If you want your attorney to argue with the co-op's attorney, that's fine. I got news for you. This is going to be a real pain in the neck. And guess what? Your fees are just going to go up because now you got a bunch of, people who are angry with each other. Just keep stuff in mind that any one of these documents may be required. Accuracy required, lien search required, trust required, some letter agreements required. However, you may require, if someone died, a death certificate, letters testamentary, a marriage certificate, an estate tax lien waiver, which in New York is called an ET 117. Some people will ask for an IRS 1352, which is the IRS liens release letter. It's not issued 10 years after someone has passed away anymore, by the way. So if I have a client who passed away in 2004 and they didn't own their, stock certificate jointly with their spouse, and it was from before 1996, guess what? The attorney wanted to get an IRS 1352 letter. They didn't offer it because the guy died all the way back in 2004. It's over 10 years. Just be patient is the point again. And here's just again, remember, if you bought your stock certificate, this is not just for attorneys to review, but if you are a shareholder and you are here for this meeting, look at your stock certificate. If you are a married couple and you bought your stock certificate or your co-op before 1996, you want to make sure that that stock certificate says as husband and wife or as joint tenants. So if it just says Dan and Michelle on it, and we purchased the co-op before 1996, you're in trouble. You each own it as tenants in common. Here specifically is the code that we're looking for attorneys regarding what happened in 1996. But if you're a shareholder that, and especially if your spouse has already died and you didn't own the stock certificate as husband and wife or joint tenants and you bought before 1996, you want to change that ASAP because it's not considered joint property with you and your spouse. It's considered tenants in common. When you go to change your co-op, you're going to have to go through estate administration or probate for that deceased spouse. All right, so that's a lot of fear right there. All right, this is not a high priority for most of the parties involved. I hate to say it that way. The co-op's attorney, they got so much going on. The management company, they have too much going on all the time already. So, they're dealing with a lot of issues already. So, of all the things they got to deal with, out of a list of 1 to 10, your item is probably number 12 at best, maybe number 52. I've seen some co-op attorneys and management companies that are just hot, so hot. I love those. They're pretty rare and they're few and far between. Usually it takes a little bit of time. Remember, I said 3 to 12 months, kind of at a minimum. Okay, if you can't find your original stock and lease, guess what? You added some time to this process. Maybe easy, maybe hard. But if you have them, good for you. If not, their absence tells you many things. This is for your kids too. If you pass away, by the way, it may tell you that there is still a mortgage. Can't find the stock. Where's the stock? There may still be an outstanding mortgage. You should still have the proprietary lease. If you can't find the stock or the lease, you may have lost it, which is not a surprise. So if there is still a mortgage, the payoff bank still has it. So, the mortgaging bank still has it. You may choose, and the co-op may require you to pay off the mortgage first before you change the stock and lease. Or you may have to have the bank come to refinance the mortgage with the trust as the borrower. So like I said, if you still have a mortgage, you want to transfer this co-op into your trust, there's going to be more time. It's going to be more work for the attorney. If there's no mortgage and you can't find the stock and lease, well, then you have one of two things. Maybe the co-op is nice and they let you sign a lost stock and lease affidavit. You just say, I promise I lost, I didn't sign it over to anyone else. And that would be a nice co-op. I got news for you, attorneys. If you do this a few times and then suddenly you reach an attorney that says, co-op attorney says, nope, your client lost the stock and lease, we're not going to allow an affidavit. You have to get insurance. That is called an Eagle 9 policy. So I know First American does Eagle 9s. My job isn't to call out great title companies. First American. And I also like Title Vest. But the idea here is that there's an insurance policy that is involved here. That if they say, no, we're scared your client sold or transferred the stock and lease already, I don't know how they would do that without the co-op legitimately, guys. Come on, let's be honest. But they may require an Eagle 9 insurance policy, which again is a fee that your client's going to have to pay. Now, if there's an outstanding mortgage, I won't go through this too much. Remember, especially if there's Medicaid involved, you can't have an open HELOC. Having a mortgage and you're doing a Medicaid trust, these are the types of things that are really going to kill the transaction. You gotta, especially if you want to do a Medicaid and make yourself Medicaid compliant, you can't have an open HELOC, right? And, a HELOC getting set up with your trust, you can now at least have reverse mortgages with co-ops, which is something new just in the last few months. But, especially if you're doing a Medicaid trust, having these mortgages is going to kill you, So just keep in mind, you got to know what's going on with elder law if you're doing a Medicaid trust and what is and is not permitted with the mortgage. And, again, co-op may say, hey, we aren't going to allow an irrevocable trust, even if the mortgaging bank does allow you to do that. So just keep that in mind. A mortgage can kill this transaction as well. Okay, we asked for costs. Are you ready, guys? This is at the low end. So if you are a shareholder, you say, all right, I want to get this job done. I'll break down the fees for you and you figure out how much this is going to be. I say this is standard if there's no flip tax. All right. So typically you're going to draft a trust with the attorney. All right. Medicaid trust, let's be honest, people will do it for as low as $3,000 if they're desperate. More expensive people, probably around $7,000. I will confess I am somewhere in the middle of that. I think I'm good enough to justify charging somewhere in the middle of that. And then overseeing the transfer process. Okay, say this is $2,000. Good luck. There's a lot of back and forth with all these parties. The more parties that are involved, you have a bank. Can you not find the stock and lease? Do you have a difficult process between the co-op's attorney and the management company? The more parties that are involved, the more that's going to be involved here. So when a client is asking, how much is this going to cost? And your attorney says, $2,000 to $4,000. You know what? They lied to you because they messed up. You say, put it in writing, attorney. If I was an attorney, I would tell you guys, you got to charge hourly to oversee this transfer process because this takes a lot more time than you think. Okay. Then the co-op attorney, guess what? The co-op doesn't pay them to review your trust. You pay them as the shareholder. I've seen $1,500. I've seen $5,000. I've actually seen some schmucks charge more, and I call them that because some of them are really just being awful about things. You really got to know how this attorney charges beforehand, because especially if you're doing something you've never done before, they're going to rack up huge amount of legal fees. They are just usurious in some cases. But if the co-op's attorney is the required party, you're going to have to pay them whatever they're asked if you want to do this. Let's go over more fees. Okay. Oh, I even went one too far. Ha ha ha. There's more to pay for the lien search. You're looking at 250 to 500. You know, if you're paying like TitleVest or someone else to do the ACRIS paperwork or TP 584, that's another 300 to 500 bucks. The Eagle 9 policy, if you lost the stock and lease, that's about 0.1% of the value of your co-op. So yeah, the $2 million co-op, you're probably looking at a $2,000, you know, Eagle 9 policy charge. That's, don't quote me if I'm totally wrong on that. All right. Uncle Dan is doing his best here. Okay. So the co-op costs, the co-op, specifically the management company, let's say, is going to charge their cost as well. They're going to cost, you know, $300, $2,500. It just depends on the co-op. They charge per share, and they also, you know, the management company may have another cost. So you can actually cross out co-op costs. This is technically the management company. But remember, they may ask for an escrow, which you get back when you move out of the apartment, or when you die, your heirs get it. And that escrow can be up to 12 months worth of maintenance. Know that before you do this, people, and especially know the flip tax. If your co-op charges a flip tax because the co-op itself is like, hey, here's all this action going on here, we got to get paid something, we're going to charge a flip tax. Wait, there is a flip tax? Maybe. Not every co-op charges a flip tax, but I have seen 1% to 3%. What does that mean? Client of mine owns an apartment on Billionaires Row. They're not a billionaire, and their apartment isn't worth $1 billion. Let's say it's worth $10 million. For them to transfer their co-op into a trust, the co-op asks for 3%. So to transfer just to the co-op that $10 million, you know, piece of property or stock and lease to my client's trust, the co-op's getting $300,000 on a $10 million property. It's called a flip tax, but it's not a tax, right? So come on, let's be honest. This is just co-op charge. And hey, co-ops are entitled to their money too. And it's in apparently the bylaws. If it's not in the bylaws, go after your co-op, because it's really got to be in the bylaws. But there is a fee that will be assessed by these co-ops, and it can be a lot of money. My client had a $10 million property said, you know, $300,000, not worth it. And I don't blame them. That's a lot of money. Here's just a quick note. If you got divorced and you never changed the name on your co-op and you're trying to change it to a trust, heck, if you're just trying to change the stock and lease to your name, there's a 1% transfer tax that was due as of the date of your divorce, and you have to pay half of it. That's right. So if you and your spouse bought a co-op for $100,000, you got divorced, and the co-op is now worth $500,000, you get to pay a capital gain to New York City, or a transfer tax, not really a capital gain, but it's a transfer tax on 1% on $200,000. That's right. But now I waited, and now the co-op is worth $900,000. I never changed the owner this whole time, even though we got divorced when it was worth $500,000. Now it's worth $900,000. Guess what? There's an $800,000 gain. Yep. You may owe a transfer tax of 1% on $400,000. But wait, he was a jerk. We should have changed this years ago. You can tell it to New York City that, hey, I should have done this when we got divorced. I should only pay that, you know, 1% on $200,000 when we got divorced, not the 1% on $400,000, because here 10 years later, I'm finally doing it. Have fun with that. If you're an attorney and this is news to you, here is your code section you want to look up. That's right. New York City does charge a transfer tax on the tenant who owns the co-op. This could have been easy if it was a condo, because before the divorce, you just could have made the transfer then, and then you avoid that, you know, transfer fee. But co-ops take more time. You need the co-op to be involved, et cetera, et cetera. So this usually comes to bite co-op owners more than condo owners. Now, the last question is, do you want to be the first person in your co-op to try a transfer? And the answer is probably not. This is the big reason. You're paying the co-op's attorney to do this transfer, but they've never done a Medicaid trust before. They've never done a Coop before. You have to pay that attorney to figure out those legal fees. And guess what? Everyone else in that building is like, well, we're going to wait till Marcy figures out how much this is going to be, you know, and Marcy's family, they're going to pay all this money. Guess what? Now our attorney knows how to do it. Thank you, Marcy. You paid $20,000 to the attorney. Now we get to do it for $3,000 because the attorney knows how to do this. Yep. Do you want to be the guinea pig? And the answer is probably not, because the co-op's attorney is going to be charging you for everything. And now they know their processes are going to charge the next 20 people a heck of a lot less. Some people must do this process. Like I had one case where the co-op was millions of dollars and the client had to do a Medicaid trust. They had to do a Medicaid trust. They paid a lot of money to that attorney to figure this out. And I was negotiating those letter agreements, just so you know, fellow colleagues, a lot. Just keep in mind, this is what you got to do. Or if you really, really want to avoid probate, then you got to do it. Just remember, you could be paying a lot of money. So when I said $7,500 to $15,000, that's a reasonable range for something that's easy. When I say it could cost you up to $40,000 or $50,000 without a flip tax, could happen too. Wait a minute, I have to pay $10,000 just to transfer my apartment. That sounds pretty reasonable for a flip tax. That's 1% on $1 million co-op. Just be ready for those things. All right. What are the transfer documents? Very simply, I'll let you look at this really quickly, but I'm going to go through each of them. I'm not even going to tell you about the stock and lease again. In fact, so much I didn't even put a number 1 in here. Get that stock and lease. All right. You need your proposed trust. Your attorney can use a lot of standard revocable or irrevocable trust language, but remember the co-op may require specific things in the trust. So attorneys hint, you may need to change your spendthrift clause in the trust. A spendthrift clause says, by the way, no one can go after certain things to my beneficiaries in here. You're saying that the co-op can still go after you specifically in the co-op, in the trust, even though that you have a spendthrift clause that protects certain people from creditors. The co-op probably wants a carve out in that spendthrift clause that you put together. Now, remember, your trust can be, you can have your co-op owned by 2 trusts, you and your spouse, or you can do one trust. One spouse owns the property in their trust, or you could do a joint trust. I know I got a bunch of colleagues who I know in my study group. Yep, we put on those little black caps and everything, and we get together and we talk about things. And they hate joint trusts, and I say, well, we can do joint trusts sometimes. You got to figure out what kind of trust you want to put together. You need to have a lien search done. And the lien search officially tells the co-op, hey, look, I'm not a big baddie who owes a bunch of money to, a legitimate creditor like American Express. I do not have an outstanding bankruptcy. I do not have someone who won a lawsuit against me and I owe them $1 million. Your lien search must be clean and clear before the co-op's attorney is going to clear you to close. So again, like I said, you need to do a lien search again, not just on yourself, but on the person who will be the trustee and on the property as well. Now, remember, you as the attorney or you as the client who's working with your attorney may see some stuff. You say, okay, these debts are legitimate. I owed a parking ticket. I never paid it because, screw New York. And now you owe the parking ticket to New York because it's on your lien search. You better clean that up because the co-op's not going to transfer the stock and lease to your trust. There may be errors on the lien search. There may be, for example, you paid that off, or the mortgage payoff never made it to your lien search, those types of things. That's an error. Your attorney and you are going to have to fix that up. Sometimes you have a common name, John Smith. Well, a bunch of John Smiths out there have bankruptcies. You're going to have to figure out how to get that off the lien search, or you're going to have to tell, frankly, the co-op's attorney, hey, John Smith's a familiar name. John Smith signs this document that says it's an affidavit and none of these are him. And sometimes you'll just find a lien that was unintentionally placed. I had clients who hadn't been late on a bill probably 30 years. I mean, maybe not even any of their lives. And they saw this wrong person's name who was attached to their apartment. They said, I've owned this apartment for the last 30 years. What's this guy having a lien on it? It was just an error that was on there. You as the attorney or you as the client helping your attorney got to clean up that lien search. Remember, a lot can happen when you send this lien search to the attorney, and then 3 months later, when you finally get to the closing, you're going to want what is called a lien continuance up until the day of the closing. So you're going to call the company that did the lien search for you the day of the closing and say, hey, send me an update, a continuance for today. Some co-op attorneys may let it stand from a few days or weeks ago, but a 6-month lien search, not going to cut it for most co-op transfers. Okay. Just to remind New York City attorneys, Guess what? Oh, here, I have the water and sewers. Take that off. Bad, bad, bad. Boo, 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 boo. Not on there. Your attorney needs to fix up the transfer documents. Whitney, please remind me to take this off of the slide. You're going to see it on the webinar, but you do not sign the water and sewer billing. No, 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 no. The good news is no transfer taxes are due unless you had a divorce or unless there was some other issue. The bad news is that, you know, your attorney does have to continue filing all these city and state documents. For anything in the states, TP 584 for New York City, it's the smoke detector, it's the NYC Department of Housing, and it's the transfer tax return. It is not water and sewers. No, 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 no. No attorney who sues me in the future. I know, don't do that. Okay, hint. See if you can pay the title company instead. If you're an attorney and you're not good at this stuff, find a title company, find a First American, find a title vet, someone else who will do this for you. And client, you'll appreciate it because then it's done less expensively. And frankly, you know, your attorney is focusing on the stuff that they're better at. Okay, they may require your attorney to sign an opinion letter. So I create a trust. And the co-op says, well, we want someone to blame when things go south. So Dan, we want you to write an attorney letter that says, hey, this trust is valid. It's a valid Medicaid trust or a revocable trust. And there's, you know, the person who created it perfectly willing to do it. And it states that my client still has to pay any fees that are due if the trustee doesn't pay it, et cetera, et cetera. So if you want to ever see a client an attorney opinion letter, you know, they're relatively easy. Some co-ops will even provide you with their attorney opinion letter. If I know you and I like you, I may share mine with you. Anyway, so keep that in mind. You're probably going to have to create an attorney opinion letter. Again, the co-op's letter agreements, those again are the documents that supersede the trust. If Uncle Dan plays something sneaky in there, like see, I say if I put in a dirty trick, they say, we got you, Dan, because we have our own documents that supersede any dirty trick you placed in there. So again, their letter agreements, you have to review them as the attorney. Client, what are they? They're documents you should not be reviewing yourself at first glance. You should let an attorney review these for you. That's why you're going to have an attorney do this. Do not do this without an attorney. You got to be crazy. Okay, the occupancy agreement. Again, these are names for some of these letter agreements. The names of these documents will differ from co-op to co-op. But basically, if you see an occupancy agreement, it's just going to state who are the tenants in there. And it also states explicitly who cannot live in there, so that, you know, co-op that wouldn't allow my client's husband to live there after she passed away, shame on you. That was in the actual occupancy agreement. Some places just call the proprietary lease the occupancy agreement. What? Yep, that's right. So co-op to co-op, sometimes they change the name of these documents. There's going to be a personal guarantee that says, okay, you know, Dan transferred his property in this trust, and even if Julie is his trustee, Dan is still liable to pay this stuff, especially for a revocable trust. But the co-op just wants to make sure they're getting paid. They don't want you to place the co-op in an irrevocable trust and then say, hey, Dan, you think you got away from us? You think you don't have to pay maintenance anymore? We know ways to make you pay maintenance. And it's going to be through this document. I have to sign a letter agreement that's a personal guarantee. Again, there's another type of document that is typically referred to as a stock power. It just says, I haven't given this stock, you know, to anybody else in the meantime. But again, these letter agreements have content in them that your attorney is going to want to review. For the attorneys, they may not have these exact titles, but keep in mind they're documents you're supposed to review beforehand to make sure your client's not putting himself in a bad situation. So again, I guess I kind of just, you know, answered this comment already. You want to negotiate things in a letter agreement, attorney. So for example, if it's a Medicaid trust, you may want to try to add language to the letter agreements regarding live-in home health aides. Some co-ops say this has never been a problem. Here's where we allow it in the bylaws. And please put it in the letter agreements, right? Okay. Again, you want to make sure that, see if it's possible to allow, you know, the spouse to reside in the property. You can try with kids. Like I said, on rare occasion, the bylaws allow it. But, you know, you're typically going to get rejected from certain people being allowed to live in the co-op when you transfer it to a trust. Remember, your trust can say, my spouse can live in there forever after I die. The letter agreement says, oh, by the way, the fact that Dan put that in the trust, we could care less. Our letter agreement says otherwise. You know, Dan had better be checking that letter agreement and try to negotiate with that attorney. And again, adult children, we'll see if that's even possible. You know, can they live with them? What happens if the tenant goes to a nursing home? different things. So you got to negotiate those letter agreements, attorneys. And again, beware of, if you're an attorney or if you're a shareholder of a co-op trying to decrease your rights. A lot of original shareholders in a co-op have better deals than new people in the co-op. Maybe the bylaws got changed, and the only way they were able to change the bylaws was to tell the original owner, say, we're going to change these bylaws, but you're grandmothered and grandfathered into the old cool rules, right? You want to make sure when you are placing the co-op into the trust that the letter agreements don't actually decrease your shareholder rights to any new bylaws. That's why, especially if you're a shareholder, you got to tell your attorney these things because you'll know them better. Is the attorney's job to review all the documents? It's the attorney's job to review the documents you bring to them, right? They're supposed to ask questions, but at some point the shareholder knows a heck of a lot better because you've lived in the building for 30, 40 years. And how much do you want to pay the attorney? You want to pay the attorney $20,000, go through everything that's ever happened with your co-op? That's cool. I'm cool with that. You probably don't. So be involved with telling them any rights that you have. And again, this is an example of an easy negotiation or revocable trust where, husband and wife are going to keep living there and they're already the shareholders. Harder negotiation may be Medicaid trust because the co-op may or may not allow it. Maybe one of the first times they've done it. Or if you're changing tenants, if you're trying to maintain child's occupancy rights, may not happen, but it's definitely a harder negotiation. The worst negotiations are those first-time transfers. If there is an existing mortgage being financed, or again, if the board, the management company, the attorney, everyone's lackadaisical. Let's say I have too much to do. That's a bad negotiation when I'm the guy and I'm, everyone else is already making it hard. So just remember that some of these things regarding letter agreements take more time. This is the attorneys only section because we are short on time. And I don't even know how short we are. Oh, we may even be overtime for all I know. Maybe we are. Let's continue. Anyway, these are the things an attorney should do. And then we will wrap up. Day before the closing. Knowing what you were supposed to be doing throughout here. And again, if you're a shareholder, feel free to stay. But again, before the closing, I would say the attorney should be holding on to the original stock and lease. Don't risk your client bringing it in to you at the closing. I know you're good for it, client. Make your attorney do this stuff. Or at least have your lost stock and lease and confirm the Eagle 9 closer. The insurance person will be there that day. Yep, Eagle 9 will probably require a closer half the time. You will need a copy of the trust. And if there's a certificate of trust, bring that too. So you can give it to the co-op because the co-op wants to probably hold on to it. When I say the co-op, it's the management company most likely, and maybe the attorney too. You will want to make sure you've reviewed your transfer paperwork. And you'll want to bring your notary stamp. I say bring it, but have it prepped. And confirm the address in the close of the closing. Remember, you may have been dealing with the co-op's attorney the whole time. Now you're going to the management company, right? And confirm with the attendants where everyone's going to be. And again, make sure everyone knows what time the closing is and where they're going. Here are the following people that need to be there. The shareholder or shareholders, mom and dad. All trustees, if it's a Medicaid trust. Remember, mom and dad have to sign over the stock certificate, but they still need their kids as the trustees of the Medicaid trust to come and to be able to sign the new documents, right? The new proprietary lease. The closing entity. So if there's going to be a attorney or the management company doing the closing, you want to make sure that they're available, that they remember it's happening there. The mortgaging bank, you're probably going to need a representative to join you. And if you have an Eagle 9 policy because the original stock and lease was lost, you're probably going to make sure they need their agent to make sure they're going to be there as well. So it depends on the parties. You also want to confirm whether all bank checks that are required are already ready. The co-op may want to have certain types of bank checks ready. Things like, a flip tax is definitely going to want a bank check. And tell the client to bring a checkbook for all these other expenses that may come up. You have to make sure that all liens are cleared, right? You want to run a continuance the morning of the transfer. All those liens you found months before, you got to make sure that those are ready or else they're not going to close. You may get lucky enough for them to close in escrow, but I'll tell you, for transferring of a stock and lease to a trust, that's the last thing the attorney wants to do. Close an escrow on a like party, it's probably not going to happen too often. They may wait a few days and give you a courtesy. Everyone's human. They can make mistakes, but you got to do your best to avoid them because this is a difficult process. Okay. Now, if you are going to be bringing the trust or you have to bring the letter agreements, you usually don't have to, but bring a copy of the most recent ones, even if the co-op attorney is going to bring them. Why? You may have gone through several drafts. I went through 11 or 12 drafts of letter agreements for one case. I wanted to make sure that that attorney at the closing knew that we had the right version. So fortunately, when I showed up, he had the right version. But if he had the wrong version, now that's a pain in the neck. Now you have a big argument. So make sure you have a copy at least of the right letter agreements, even if the co-op's attorney is going to be signing them. Make it clear to the client that this is the last day to talk about this transaction. You don't want questions at the closing. I know, client, you're going to have a ton of questions. This is not a good time. There's a lot going back and forth. There's a lot of paperwork regarding the co-op, regarding the trust, possibly regarding Eagle 9. There's a stock certificate and multiple copies of the proprietary lease. It's not a good time to do this. And remember, there's going to be multiple documents that are involved here. You typically need 4 copies of all documents. Why? The co-op's management company gets a copy. The co-op's attorney gets a copy. Your client gets a copy. And guess what? You as the client's attorney get a copy. You'll also, especially if you're closing at your office, want to have 4 copies as well, because that's who the co-op's going to want, a whole bunch of copies. You're going to need to send all of them to the co-op, who's going to sign off on them and send you back 2 of them. Remember, the co-op wants you to have a copy of the ACRIS and TP 584 documents. And when you sign them with your client, the management company is going to want a photocopy before you send them off to get registered. At least they want to know, they're not going to check if they're actually updated, but they want you to know you actually did it. And remember, if you're the client's attorney, you best do that, right? Because your job isn't done unless the ACRIS documents are turned into New York City and the TP 584 is turned into the state. So again, the management company wants a photocopy of that before you leave the closing, even though you haven't given them to the city or the state yet. Now, here are some of the what ifs that come up. Be prepared. So again, if this was, a correctly jointly owned property, you'll want to bring a death certificate. And if it wasn't a properly owned, pre-1996 co-op and the co-tenant died, you want to have an updated letters testamentary that's valid, last 6 months. And you'll need to show these to, the co-op's attorney, because they want to validate that this other tenant either was truly jointly owned and that other tenant is dead, or that it wasn't jointly owned, but you have letters testamentary that allow you to transfer it. And make sure they know beforehand, because again, the paperwork's going to look different when we're dealing with an administrator or an executor, right? Some of those signatures are going to have to be made by the spouse, possibly the spouse or the child, as administrator or executor. If your client, with the case with Medicaid trust, is incapacitated, make sure their power of attorney brings, or their agent under the power of attorney brings that power of attorney, and make sure it's in the paperwork beforehand. Imagine getting to the closing, you have all these letter agreements, and you have the incapacitated client's name, and now you tell the closing attorney, hey, guess what? We actually have the power of attorney here today. You're going to have to redo all of that paperwork at the closing. That's going to be like a 4-hour closing. And believe me, you have made no friends. If anything, you made your client pay more money to the co-op's attorney. And again, you will probably, again, want to have either an original power of attorney, or again, you can do that attorney certification. Again, here's your general obligations law section that you can show. Keep that there. You may want to have, again, your client, if your client is the child or the agent under the power of attorney, sign a full force in effect if it's an old power of attorney. I would say do it anyway, right? What's the harm? You made a power of attorney for mom 3 months ago. She can't make it to the closing. Guess what? Have their child do a full force in effect anyway, right? What can go wrong? Remember the assignment of the mortgage. You'll need to bring all assignment documents. The bank want to have their own closer there as well. May want to have their own closer at the closing. Unless the shareholder is impaired, this should only take approximately an hour. If you're dealing with 2 units, because sometimes the client owns unit 7A and 7B and they aren't joined, maybe it takes a little longer because you're doing 2 copies of the document. Remember, this is not the time to review the documents, right? Because everyone's on the clock now. Now you have the other attorney there as well. Your attorney should, again, make sure, and if you're the attorney here with me right now, bring your notary stamp. You want to take your time. Every closing is different, and every signature that people miss is going to need to be signed again. Don't feel like you have to close within an hour. If it's going to take you 2 hours to go through everything, go through everything. If you have a title attorney person there helping with the Eagle 9, ask them to maybe help with some of the notarizations. You know, you're going to be explaining a lot to your client already. Hopefully they're not asking questions. So get some help. You know, even ask the co-op's attorney if they're willing to sign, if you feel good about the document. You as the attorney get paid at the closing. Now you want to build in stuff for the post-closing activities you're going to do. Make it easy. Let the client just be done with it this day, right? Have them pay you at the closing. Build in a little bit for the post-closing activities. You're going to want to bring all the documents back to your office anyway. You don't want your client leaving with everything that day because you probably want to do some scans. You may want to do a formal, you know, like closing statement, like if you do real estate closings. Do your client a favor, build in the cost of a FedEx for $50. Just bring the documents back to your office. Make sure you have copies of everything, because who knows what happens to your client. You know, you want to have a copy of this. This is your work product. Okay. At the closing again, you need the current owner to bring the old stock certificate, which they're going to sign over. Any assignment of the lease, you know, stock power is going to be prepared. Those are the documents your client needs to sign. The new, and when I say the client, I should say the current owner, changing owner. The trustee will sign the guarantees, the occupancy agreements. They'll accept the assignments of the lease, and any, you know, proprietary lease they will sign over as well. So the old stock certificate gets signed over by the old owner. The new owner, the trustee, will sign the proprietary lease. And these are the other things that will get signed over, you know, the New York transfer paperwork, New York State, New York City, like the ACRIS documents and TP5 anymore, and any additional co-op riders that may have been come up with. After the closing, confirm you have all the documents, and you're going to want to scan everything. If you want a paper copy, that's fine too. You're going to end up with a big file, but it is what it is. Sometimes you have original copies. You want to send the New York transfer paperwork in ASAP. Don't mess around. Get this done. Scan a copy of all documents electronically. Like I said, send the closing letter to your client. Guess what? When you send them the file, you also want to close, you know, begin the statute of limitations rolling. And just remember to set a calendar invite at some point to make sure that your, you know, transfer paperwork has been uploaded, especially for New York City, where it's free to look up ACRIS. You know, send a reminder, just make sure that, you know, everything's been updated properly with them. They've kind of caught up a little bit there. It's not as bad as it was during COVID. You want to see a hard transfer process, try seeing this during COVID when you couldn't meet people face to face. Consider yourself lucky you've only had to go through all this. So is this all worth it? You know, here you get your old school favorite. Dan says, I'll have to change that because the hairline's changed. But the answer is yes. It's still almost always worth it, despite the fact you paid $15,000 client. It's better deal with past problems now. You know, you have one of those stock certificates that's messed up. It's pre-1996 and it doesn't say joint or husband and wife on it. Deal with that now while one of you is still alive. Again, it reviews all those lost opportunity costs during, you know, waiting for probate. The court, 3 to 6 months. That's 3 to 6 months or 9 months or 12 months that you're paying real estate taxes, maintenance, utilities. You could have had this apartment ready to be listed for sale 2 days after you passed away. I still think it's worth it. It may allow for Medicaid protection if the co-op allows it. You're not going to get that from a will. Of course, that's worth it. If you end up going to a nursing home 7 years from now, guess what? You paid $15,000, maybe tops, for this trust. You save $20,000 the first month that you go to that nursing home that you're not paying out of pocket. And it allows you to know that your estate is going to be much easier later after you pass away. I'll take any remaining questions or comments you may have. I know we went over today, but I thought it was important to do this in full because this is not an easy process. I want to thank you all for coming, and hopefully we will get together again to do a new webinar sometime in the future. Thank you so much.